Sure, I'll let people in.
Welcome everyone. We're going to start in a moment. I'm watching the screen to see how many people are entering the waiting room. So it looks like we have most of the people online in. And so, welcome to the first webinar in the winter series of Contemporary Challenges in American and Global Law. I'm Leah Wortham, Professor Emerita at the Columbus School of Law of the Catholic University of America. I'm the Catholic University Director of the American Law Program and the LL.M program, in which Catholic University has cooperated with Jagiellonian University in Kraków, Poland for many years. I will be your moderator. Louise Leiden, the Executive Director of Development and Alumni Relations for the Columbus School of Law, will bring greetings from our law school.
Thank you, Professor Wortham. It is a pleasure to be here with all of you today, and Happy New Year. I want to take a moment to thank Professor Wortham for her leadership from our end in putting this particular program together and recognize her efforts to foster and cultivate the relationship with the best law school in Poland at Jagiellonian University. She's built on the deep roots established by Emeritus Professor Rhett Ludakowski, the founder of our Catholic Jagiellonian relationship, who many of you know. Catholic law cherishes this 30-year relationship with Jagiellonian University. The International Business and Trade Summer Law Program, American Law Program, and LL.M in American Law now have more than 2,000 US, Polish, and other international alumni. I'm excited that we are growing this community through these Zoom meetings, and once again want to thank Professor Wortham and our Jagiellonian partners in creating even stronger ties with and among our alumni. The panelists today are outstanding, so without further ado, I'll kick it back to you, Professor Wortham.
Great. So Wojciech Bańczyk, coordinator of the American Law School at Jagiellonian, will now welcome you on behalf of their university.
Thank you very much, Professor Wortham. Dear participants of the summer series of webinars, it's a great pleasure for me to express on behalf of the Jagiellonian University the great joy that you all joined us in the online meeting, showing your interest in the contemporary challenges in American and global law. We are very happy that in the year 2021, for more than a year right now, we are meeting. Last year, more than 1,000 of you joined our webinars, and it's a source of our great satisfaction. We also believe that in even larger groups, we will meet this year, and sooner or later, we will meet in person during our programs or alumni meetings. This position allows me also to present the gratitude to all the persons without whom it will never be possible for this event to happen. Additionally, it allows to announce a great pride for Jagiellonian University to co-organize such an interesting event. The event, which also proves that the fruitful cooperation between the Catholic University of America and the Jagiellonian University continues despite difficult pandemic situation. Given the current difficulties, we are happy to develop a new initiative so that in the absence of traditional insight meetings, we could offer a new way to learn and to meet together. Thank you very much, and I'm also strongly looking forward to an excellent webinar today.
Thanks. This webinar is a team effort, starting with the support of Dean Stephen Payne of Catholic University and Dean Jerzy Piszyliński, the Dean of the Faculty of Law and Administration at Jagiellonian University. It draws on the leadership and staff of the Jagiellonian Center for Foreign Law School Cooperation, often referred to by its Polish acronym OXPO, and the Law School Development and Alumni Relations and Communications Offices, as well as the Central CUA Development Office, who helps us a great deal, including with tech support. We also are assisted by our LL.M coordinators, Gaspar Cote and Luke Bartosik. Please check the website for information on the upcoming 5 webinars in the winter session. There are various points of access from the CUA website, which will take you to the series website if you would like to see it, which is maintained at Jagiellonian, and there are easy one-click ways to register on our website. In the upcoming webinars, there are fascinating topics of current interest about what the new administration may bring as differences in public international law, about the parallels in the budget processes of the European Union and the United States, how well the financial system put in place 2008 may withstand the COVID crisis, and other exciting webinars. So please do check out the series, and we'll see you in the upcoming webinars in the winter session. And we also I think the URL is going to be in the chat where you can register and see the website. So we now turn to today's program by LL.M alumnus Vincenzo Senatore on a civil and common law analysis of whether COVID-19 will be a force majeure event, considered a force majeure event in commercial contracts. Our commenter is CUA JD alumnus and Law School Board of Visitors member Andrew Palmieri. So Vincenzo, you can go ahead and put your slide share up while I introduce the two of you and say a few words about the organization of the webinar. I expect most of you have now used Zoom or similar video conference platforms many times, so you know about typing questions in chat. I will take the questions from the chat and pose them to our speakers. You can type your question directly in chat, or if you prefer, on the drop down in the chat where it says to everyone, you can hit that drop down and you could send a question to me privately, or to Wojciech Bancik, or to Luke Bartosik personally, privately, and they will forward it on. So if you would like us to do that, we're glad to do that as well. In addition to the chat button, you can see a participants button at the bottom. If you click there, it lets you see the names of people who are signed on. So you can look for colleagues and classmates, and you do have the option here to send private messages. So if you want to say hi to a classmate you haven't seen for a while, just choose their name and you can shoot them a private message. So in addition to the interesting webinar and Q&A, so as I said, so those will allow you to sort of simulate some of the networking that one is allowed to do in a live event. So unfortunately, the registration software does not recognize some Polish characters. So we apologize if a letter in your name shows up with a question mark. To avoid that when you register, please just use the English characters. So Mr. Senatore will speak for about 20 minutes. He will be followed by a comment from Mr. Palmieri, who will also lead off the question and answer period. As I mentioned before, please type your questions in chat as you think of them, either to everyone or send them privately to Mr. Bancik or Mr. Bartosik. After Vincenzo answers Andrew's questions, I'll pose the questions from the chat. The session is now being recorded, and the 60-minute webinar will be posted on CUA's YouTube channel within a few days. The series website links to those recordings, so you can check out any of the recordings from the fall session already. At the end of the 60 minutes, I will close the formal webinar and the recording will cease. Mr. Senatore and Mr. Palmieri have graciously agreed to stay on for up to another half an hour so we can take more of your questions. So I encourage all of you who have the time to stay with us till 2:30 or 8:30 to stay on, and we will finish up the questions. So in the chat, you can now see links to fuller biographies for Vincenzo and for Andrew. And I will now say a few words about each of them. Vincenzo Senatore is a CU LL.M from 2010, and he is a partner in the London office of Giambrone Partners LLP. He heads the London Corporate and Commercial Department, as well as the firm's international criminal law practice. In 2019, the European Legal Awards ranked Giambrone Partners as one of the top merger and acquisitions firms. Top Legal, the most prestigious Italian legal ranking, named Giambrone Partners as the Italian Law Firm of the Year in 2018. Vincenzo is an Italian-based licensed attorney, a qualified solicitor in England and Wales, and recently was admitted as counsel before the International Criminal Court in The Hague. He is regularly retained in high-value commercial litigation and large international arbitration matters. His practice includes company law, debt recovery, corporate and general commercial agreements, and other business law matters. Mr. Senatore also represents international English-speaking clients in cross-border criminal matters in Italy. In 2015, he was a fellow at the Stanford University Center for Biomedical and Ethics, working on contentious issues arising from stem cell research related to biotechnological inventions. He's a frequent conference presenter and media commenter on cross-border matters between the UK and Italy. Vincenzo received his law degree from the University of Naples, Federico II. Andrew Palmieri is a partner in the Washington, D.C. office of Saul Ewing Arnstein Lehr, LLP, a full-service law firm with 16 offices that serve businesses throughout the United States and internationally, including recognizable names in corporate America, exciting startups, an array of closely held and privately held companies, as well as nonprofits and governmental and educational entities. Andrew represents real estate developers in acquisition, development, finance, leasing, and disposition of national, regional, and local commercial real estate projects. Nationally, Andrew is a past chair of the American Bar Association section on real property, trust, and estates law, and he presently serves as an officer of the American College of Mortgage Attorneys. Internationally, Andrew is a trustee emeritus of the Board of Trustees for the American University of Rome. In this capacity, Andrew has gained a perspective into the needs of higher education and the global economy. The knowledge and context Andrew gains through his involvement in these varied organizations enables him to provide legal advice that takes account the industry trends that clients face in advancing their business interests. And we now talk about one of the major trends faced by businesses and everyone else all over the world, COVID-19. So we turn to Mr. Senatore to begin his presentation. Your screen share isn't up, Vincenzo.
Here we go.
Okay, we need to get your screen share up. And, okay, and you can go to the current slide. There we go. Okay, we're all set. Okay, thank you so much, and be thinking about your questions in the chat.
Thank you. Thank you. First of all, I would like to thank you, Professor Wortham, of the Catholic University in Jagiellonian, for giving this opportunity to be a speaker of the series, series of webinars. So today we speak about the COVID-19, be a force majeure event in a commercial contracts, a comparative analysis between civil and common law arena. With the spread of coronavirus throughout the world, actually companies are beginning to invoke a force majeure to limit their contractual liability in the face of performance difficulties they encounter with their co-contractors. The spread of the virus does multiply the use of the concept of force majeure with a domino effect. But
Vincenzo, before you go any further,
yes.
I'm going to ask you to talk just a little bit slower. And we are having it is cutting out a little, in and out a little bit. You might want to lean back a little bit. And also it'd be good maybe just to speak just a little slower.
I will. So I will start again or just continue?
Why don't you actually start again? Because I was having a little trouble.
Okay, that's fine. So today we speak about the COVID-19, and it's a force majeure event in a commercial contract. My topic will be will face a comparative. Will deal with a comparative analysis between civil and common law arena. The COVID-19, it's as we know, is spreading throughout the world, and some companies are beginning to invoke force majeure to limit their contractual liability in the face of performance difficulties they encounter with their co-contractors. So that the spread of the virus could thus multiply the use of the concept of force majeure, the terms of force majeure, with a domino effect. But what is force majeure? This is a French term that means a superior or great force. In the legal context, it refers to an extreme event beyond control of the party. The civil law recognizes force majeure as a concept operating independent of the contract language, meaning that even though force majeure clause is not included in a contract, a party might be protected for no performance by law, provided that the event has been irresistible or unforeseeable or external and has made the performance impossible. On the other hand, common law assumes freedom of contract and enforces force majeure only if provided for in contract language. So there is no doctrine of force majeure. The term is a convenient label used to refer the the clauses which relieves a party from performance of its contractual obligations, where that performance is impacted by the adverse event. We see force majeure definition in international scenarios. So for instance, in international chamber commerce, the meanings of the force majeure means the occurrence of an event or circumstance that prevents or impedes a party from performing one or more of its contractual obligation under the contract, even to the extent that the party affected by the implement proves. So that such impediment is beyond its reasonable control and is not reasonably have been foreseen, and that the effects of the impediment could not reasonably have been avoided or overcome by the affected party. So, for instance, force majeure under the ICC can be wars, rebellions, acts of terrorism, acts of good, and also epidemics and cyclones, earthquakes. Under instead convention, Vienna Convention, that is the UN Convention on the International Sale of Movable Goods, a force majeure clause is applied in practice in the intrinsic of the event beyond reasonable control, the inevitable and unsurmountable nature of the event or its outcomes. Providing the existence of the above three elements, the defaulting debtor is normally held not to be liable to the creditor. Now we see how the inclusion of current novel coronavirus outbreak into the context. So inclusion of the current novel coronavirus outbreak into the scope of a force majeure clause may vary depending on, for example, whether one or more epidemics are included in the wording of the clause. It provides for catch-all wording related to events caused by nature similar to that one at hand, and or the situation meets the requirements defined in the clause to consider an event as a force majeure. The parties are free to determine, however, not only the events considered as force majeure, so there is a freedom by the parties to define force majeure, but also the consequences of the occurrence of such events. So for instance, the occurrence of force majeure event could lead to release the debtor from the liability, or terminate the agreement, suspend the performance of the agreement temporarily, thus, or the creditor being entitled to withdraw, so discharge the contract, or seek a reduction of her counter performance. For instance, we see reduction in a lease agreement. We had there is a very recent the court wrote decision of last month where the court has reduced a rent in a lease agreement because of COVID outbreak.
Vincenzo, we've got it in chat. People, it's still a little hard to hear you. Sometimes it kind of comes and goes a little bit. It's been better right now, but perhaps just if you even just speak a little louder yourself, it might help. Just
okay.
It was better just toward the end of when you were speaking than it had been a little earlier. So
okay, that's fine. Okay, go ahead. So now we see the slide force majeure and epidemics. The question of the application of the concept of force majeure has already been raised in the past with the previous epidemics. So for instance, we remember some SARS, some decisions in Ebola in 2014, and with the SARS and H1N1 in 2009. Now the question is, does COVID translate into a force majeure event and remove or change any contractual obligations in place? The best way to understand this issue is just to show some examples for the audience under a civil law and common law scenarios. So for instance, the first example, we see a USA buyer backs out of a contract to purchase a global retail chain after the seller closes multiple stores due to COVID-19. In the second scenario, we can see a China's company refuses to buy contractually required amount of natural gas from a French supplier following a sharp decline in demand due to COVID-19. This is the third scenario. We have an Italian supplier fails to provide time-sensitive services to a Polish purchaser because the supplier's key workers fall ill with COVID-19. And the last scenario is a conference organizer terminates a scheduled June event in London after the UK government issues an order prohibiting gatherings for more than 100 people. To go through each single example. In the first two scenarios, the non-performing party seeks to avoid liability based on economic conditions created by the pandemic. Scenario one, the USA buyer no longer wants to purchase the retail chain because the pandemic has greatly reduced the number and the value of the stores. In the second scenario stated, the Chinese company doesn't want to purchase the required amount of natural gas because the pandemic has reduced the demand for the product. By contrast, in the third and the fourth scenario, so the Italian supplier and the London gathering, the non-performing party seeks to avoid liability based on circumstances created by the pandemic that prevent performance. Example 3, reduced workforce caused by widespread infection prevents the Italian supplier from timely providing the required services. In this fourth scenario, the UK government order prevents the conference organizer from going forward with the scheduled conference, although the performance is possible. These four examples provide a framework for examining the different ways in which civil and common law principles will shape the outcome seeking to resolve these emerging disputes. In both civil and the common law jurisdiction, however, the occurrence of a material adverse event can also excuse contractual non-performance in certain circumstances. In both jurisdictions, the law recognizes contractual provisions designed to allocate risk between the parties, such as force majeure and the material adverse event. This is a very interesting decision, the OWBR Clear Channels Commons Incorporation that I will describe in a later following the slides. In addition,
Francesco, you're breaking up again. Just so you know, you're going to want to. Hopefully, we'll get back to when you were speaking a little clearer, but you're breaking up. Just so you know.
Do you hear me now? Hello?
We could hear that. We could hear you better. We could hear you pretty well for a while, and then you started breaking up again. So I think it's partly keeping your voice up. And
okay, so I will just move the headphones and I use the laptop alone without. Do you hear me better now? Do you hear me better now? Hello?
yes, yeah, I think so. Yeah.
Okay, I hope so too. So excusing non-performance. So this slide we'll see in addition in many civil law jurisdictions, the relevant law includes a statutory provision granting certain types of contractual relief in the case of material adverse event. This provision not only incorporated the general force majeure principles, but also create an economic hardship type defense that is not found in the common. So, for instance, in the UNDRA principles of international commercial contracts, where the parties who is affected by economic hardship is allowed to renegotiate the contract. So we will see now the common law defense in case of COVID outbreak, the impact of COVID-19. In some common law jurisdictions, the courts recognize a breach of a contract, the defense based on impossibility of performance or frustration or purpose. Under this defense, an unforeseeable event that frustrates the contract's core purpose can provide grounds for terminating the agreement. As depicted in the chart that will follow later on, the potential civil law and common law defenses in COVID-19 contract dispute share several key elements. And the first preliminary requirement is a triggering event, with both unforeseeable and beyond the non-performing parties' control, so beyond their control. Yet at the same time, the defenses also have important differences, such as whether economic hardship is alone sufficient to justify non-performance. Here we see this chart. We can see the defense and the civil common law requirements, economic hardship qualify, and the consequences. As we can see, we can have a force majeure, and the requirement is unforeseeable event beyond the party's control that prevents or impedes performance with no reasonable alternatives. Material adverse event, where the requirement is unforeseeable event beyond a party's control that has material adverse consequences. Economic hardship, unforeseeable event beyond a party's control that make performance economically onerous, and impossibility of performance or frustration of purpose under common law, where the requirement is unforeseeable event beyond a party's control that prevents performance or frustrate for purpose of contract. There is a very important landmark decision is issued in 2019 by the English Court Appeal regarding a lease agreement between a landlord and tenants, where the European Medicine Agency claimed the frustration because of Brexit. And in this case, the court ruled that also Brexit cannot be an element of frustration, because regardless of Brexit, there is a lease agreement in place, and in any case, the European Medicine Agency should foresee that the lease agreement could be terminated. Also because the lease agreement included a break clause. So the European Medicine Agency claim was rejected, and the claim for frustration was not granted. Then we have a triggering event. So as I told previously, who the affected party must trigger the event and notify as soon as possible the event to the opposing party. So under the both civil and common law principles, a key issue likely to arise in any COVID-19 contract is whether the claimed triggering event qualifies as a material adverse event, excusing non-performance, assuming all other requirements are met. In such case, the non-performing party will invoke either the pandemic itself or a specific restrictive measures, governing restrictions such as lockdown. The definition of a triggered event is important not only for assessing its variability, but also for determining the scope and duration of its effects. Although government orders or even the pandemic itself may be found to terminate on a specific date, they can also have continuing effects that either prevent performance or make such performance economically difficult. For instance, in the Corbex SA versus Louis Dreyfus Commodities Suisse SA, the English Court of Appeals ruled that the supplier excused from liability not only because of the strikes that interfered with the cargo handling operations, but also because of the continuing congestion that delayed delivery. There is the causation analysis, and also here in both in civil law and common law principles, a non-performing party also must show that the triggering event either prevented the party from performing its obligation, common law. On the other hand, it also created economic condition that made the performance excessively onerous. This is the non-performing party must satisfy two separate elements closely related to causation is a direct causal link, and obviously due diligence in avoiding the effects of a triggering event. So coming back to our examples, the four scenarios that I mentioned before, so the causation analysis can lead to different outcomes under civil law and common law principle. In both systems, the requisite causation showing can likely be made in scenario 3, so scenario 3 was the Italian supplier above, where the pandemic reduced the Italian supplier's workforce and thereby prevented it from providing the required services. In scenario number 4, UK example, where the government ordered and prevented the London organizer from holding events attended by more than 100 people. By contrast, in common law jurisdictions, the courts generally hold that an economic hardship does not qualify as a force majeure event, even when the hardship is direct result of such event. This is a very landmark decision in OWBR. In the OWBR, conference organizer reserved more than 500 hotel rooms for an October 2001 event, but then invoked force majeure when attendance plummeted following the 1911 terrorist attack. The court rejected the claim, holding that mere economic hardship does not establish a force majeure event, even when it results from an indisputably unforeseen event. This was a decision ruled by the New York 19th District on 2001. Then we have the first scenario under common law principles. So the USA buyer in scenario number 1 and the Chinese buyer in scenario number 2 may not be able to establish an adequate factual basis for force majeure relief. In both scenarios, in fact, the non-performing party seeks to suspend its obligation, not because of the pandemic has prevented performance, but because it has made performance economically onerous. On the other hand, under civil law principle, the same scenarios, the same example, USA and Chinese buyers may be able to make a sufficient showing of economic hardship to establish a basis for either renegotiating the contract or terminating the agreement. In the absence of a statutory provision and or contractual arrangement of force majeure, which instruments are available to avoid the performance of contractual obligations. So when there is an absence of a statutory provision in civil law system, the general concept used to describe situations like those falling with the force majeure concept is the one of impossibility of the performance resulting from a cause not attributable to the debtor. So for instance, in Article 1218 Italian Civil Code, this is the civil debtor who did not perform her obligation due to an impossibility resulting from a cause not attributable to her is not liable for compensation for damages. Italian case law found supervening impossibility in several cases, such as event caused by nature, earthquakes, for instance, natural factors affecting the sphere of the debtor, such as a flu of a lyric singer, factum principis, that's an official order or measure that affects the agreement, such as an annulment of a previous favorable judgment. Also, the restrictive measures with reference to COVID-19 outbreak, it's important, interesting to describe today, because it's worth remembering that certain areas in the North Italy when COVID-19 was spread, started in the north of Italy, was only that area was affected actually, and only that the government issued the restrictive measures only in the north of Italy. In such case, one may reasonably argue that a situation like that one at stake could constitute a supervening impossibility if the performance of the relevant contract will become impossible because of the imposed restriction. Therefore, the contract could be terminated or suspended according to the civil law system. Another doctrine that I think is important to deal with is the causa in concreto doctrine. And here, this is a landmark decision of the Italian Supreme Court in 2007, which applies this doctrine in case of epidemic of dengue hemorrhagic in Cuba, which was chosen as the destination of all-in-one tourist package contract. In this specific case, the contract was considered terminated because the claimant tourists had no more interest in visiting the country, such as like the frustration principle in the common law. We are in a material adverse change effect. In addition to force majeure clauses, dispute may arise on the basis of what's called material adverse change effect clauses, usually included in share purchase agreement or another business agreement. Such clause provides that any event material adverse to the operation, assets, position, profits may cause the termination of the contract. And we are at the end of the slides. Conclusion, well, the COVID-19 pandemic is sure to generate a wide range of contract disputes, as I said in the beginning of my speech. In this case, the outcome will often depend on whether it's common law or civil law is applied to resolve the specific dispute. The important is also to have a look and check the language, the terms, read your contract carefully, identify all favorable language. And on the other hand, if the parties formed the contract before the first reports of COVID-19, the non-performing party will likely be able to show that pandemic constituted an unforeseeable occurrence that was beyond its control. And this is my last slide, and I finish, and thank you very much for your attention. Professor Wortham, you're muted.
I'm still muted, that's right. So we'll now turn to Andrew for some comments from the US side and to start off our questioning.
Okay, thank you, Professor Wortham. And I guess and thank you, Vincenzo, for your presentation. I guess the best way for me to start is to prepare you by saying, while unfortunately some of you may have had some technical difficulties hearing Vincenzo, he had outstanding slides, and I know I was able to follow along with the slides. I, on the other hand, do not have outstanding slides, so hopefully you can all hear me. And okay, I'm getting some nods and thumbs up, so that's good, because you're stuck looking at me for the next 5 minutes instead of the really pretty slides. And by the way, you're seeing me wearing a tie, which is only the second time I've worn a tie in 10 months, so I did that for you all. From a U.S. perspective, because the U.S. approaches force majeure as a common law, from a common law perspective, with mild exceptions for the state of Louisiana and some very targeted statutory provisions, any force majeure analysis is going to vary to some degree on a state-by-state basis. So you're going to have to drill down on the state law in whatever state you're involved with. Your contract should hopefully have a choice of law provision in it, which will make that easier. If your contract doesn't have a choice of law provision in it, then you have to go through a choice of law analysis and hope that you've identified all possible states that might govern that contract. And then again, drill down on how they would deal with force majeure. The one thing that is pretty consistent is that courts will interpret force majeure provisions very, very narrowly because they don't like letting people out of their contracts easily. They will focus on very specific events that would trigger the force majeure scenario. And then the party that's seeking to be excused from the performance of its contractual obligations has a burden of establishing through a preponderance of evidence that the force majeure provision is applicable to the specific event that prevented their performance under the contract. It creates a bit of a conundrum because when you're negotiating your contract, you're supposed to identify in advance things that under force majeure are unanticipated. So you have to anticipate the unanticipated, which is why so many of us found ourselves 10 months ago scrambling when we had contractual issues and we're going to the force majeure clauses and not seeing anything relating to pandemics. And we'll come back to that later in the Q&A. So it's good to have as comprehensive of a list of trigger events as possible. Some examples I'll just read off would be epidemic, pandemic, disease, outbreak, and public health events of an international or national/local concern. And of course, you tailor international, national, local based upon the nature of the contract. If your contract is purely local, you may not want to have as broad a scope as an international concern. Quarantines, the obvious and act of God, government rule or government regulations, government mandates, disruption of transportation systems and transportation infrastructure, disruption of supply chains and labor force. Sometimes, the strikes will be specifically referenced in language. National or local states of emergency. And then, of course, the ubiquitous other similar events that are beyond the control of the parties. So those are some examples, but I will say that pre-COVID, many of us took our force majeure provisions for granted. They had been in contracts for years and years, and they covered the basic stuff, but it's important to rescrub that provision in the post-COVID era. I was intrigued by Vincenzo's discussion about economic hardship and economic hardship under civil law potentially being a reason for cancellation of a contract. The United States is a market-driven economy, and claiming economic hardship is going to be difficult to use that as a force majeure defense. You could look to other common law defenses like frustration of purpose or impossibility, but it generally wouldn't be a force majeure event. And as Professor Wortham commented earlier, I come to this discussion from a commercial real estate perspective. So my perspective is looking at leases, loan documents, construction agreements. And in that context, even if you have the most robust force majeure clause, most landlords, the vast majority of landlords, are going to have a clause in the force majeure provision that excludes payment of rent as being forgiven or as being a defense for performance under the contract. So again, in the many, many leases that I reviewed between March and now, very rarely was there a pandemic cited or there were government mandates cited, but the vast majority of the time, payment of rent was not excused. So that's something that you have to watch for in that context. And it also in the leasing context, it gives me an opportunity to just diverge very briefly, because this has been an important topic in the United States, where you have a tenant that is not operating, they can't access their, well, I'll give you a really great example. Right now, my office is in Washington, D.C. on Pennsylvania Avenue. Not only am I not allowed to go to my office because we have effectively closed our offices for 9 months because of COVID, but now the National Guard has closed off Pennsylvania Avenue because of events happening in Washington, D.C. So we can't, even if we didn't have COVID, we wouldn't be able to be using our offices right now. Is that a force majeure event? It's a government action, it's a government mandate, it's government regulation. It's a time of riot or crisis. A lot of those things appear in force majeure clauses. But circling back to rent claims, tenants have been grasping for opportunities to find a way to not be seriously in default in hundreds of thousands or millions of dollars because of their inability to operate in their offices, restaurants, retail shops, etc. And there's been a bit of a cottage industry in examining whether business interruption insurance would provide an adequate means of getting insurance proceeds in order to pay rent and avoid being in default. And there have been a number of claims of some very famous American chefs and restaurant groups and even small mom and pop retailers and law firms have asserted the business interruption claim, where they have filed claims with their insurance companies. And the problem there is business interruption insurance is tied to property and casualty events, typically a fire or a flood. So you have lost your property because of, or access to property because of a casualty event, and therefore business interruption insurance kicks in. But most insurers, I would go so far as to say all insurers, have taken the position that a pandemic or a government mandated shutdown is not a casualty event, and it is not a loss of property. So in those instances, commercial tenants are really forced to either renegotiate their lease obligations as best they can with reasonable landlords, or look to state and local versions of the CARES Act that provide for assistance for those parties. And I will give an example. In the District of Columbia, as part of their emergency COVID legislation, they passed a law that allows a retail tenant, so a restaurant or store, a shop, and office tenants that occupy less than 6,500 square feet, to have the right to apply to their landlord for a rent deferral and payment plan. Now, not every jurisdiction has done something like that, but those are other remedies that can be pursued by tenants. And before I skip back to force majeure again, I just wanted to give the other side of the coin, because I indicated that the vast majority of courts are not agreeing with the business interruption insurance argument. But you may want to take a look at a North Carolina Supreme Court case, North State Deli LLC versus the Cincinnati Insurance Company. And in that case, the court ruled that a direct physical loss, and that terminology, direct physical loss, is critical language in property and casualty insurance policies that triggers the business interruption insurance. It ruled that a direct physical loss includes the inability to utilize or possess something in the real material or bodily world, and therefore the loss of the full range of rights and advantages of using or accessing your business property is in fact a property loss. And they took the position that business interruption insurance should apply. Highly unusual, but there are some courts out there that are doing it. The other aspect of force majeure that I would touch on would, while it arises from a war story involving a commercial lease, it also touches on construction. So We're presently working with a developer negotiating a 50-year ground lease with a university that will be developing a urgent care and related business facility on a series of buildings on the land that we're ground leasing. And as you would expect, we're ground leasing the land, they've got to build the facilities. So over that 50-year period of lease term, there are plenty of things that we needed to anticipate as potential force majeure, and we're negotiating this during the COVID crisis. So, you know, obviously we put in, you know, COVID and pandemic language, but in addition to the lease obligations, there's the construction obligations. Really the deal doesn't go forward until the improvements are built. So we have a very robust force majeure clause, but you have to bear in mind that notice of force majeure is also important. We wouldn't want the university to be sitting on its hands for, at this point, 9 months, not doing anything. And then when we say, hey, you're in default, you haven't hit your benchmark dates, they say, oh, well, there's a force majeure event. What we've done is we've built into the contract a specific notice provision where within 3 business days of the force majeure event, a trigger happening, they have to give notice. And then they have to keep a log that is a day-to-day log of every day that the trigger prevents them from performance. So, and that log is subject to inspection by our developer client. So just something to bear in mind from that perspective. I know that as a commentator, I'm supposed to be brief, so I'm going to try to be brief. I'm not going to repeat a number of the things that Vincenzo spoke to. Specifically, he did a nice job highlighting frustration of purpose and impracticality and those other equitable defenses. I guess my parting note on force majeure would be this. Before you decide to invoke a force majeure defense, be sure you've done all of your due diligence. You've read your contract, you've looked at the local law, you've applied the facts to the contract and the law, and you feel that you're standing on solid ground. Because when you invoke that force majeure clause, that could be interpreted by the other party as an anticipatory breach or repudiation of the contract, which gives them yet another cause of action for breach of contract. So you're just adding to the number of counts that they're going to bring in their lawsuit to enforce the contract. So again, be sure you do your due diligence on that very carefully. Professor Wortham said that I was going to pose some questions. So I wrote down a few things while Vincenzo was speaking that struck me, particularly given the comments that I was planning to give. So Vincenzo, you know, I commented that pre-COVID, most of us didn't focus very heavily on force majeure clauses, and in particular on pandemics. But you rightly noted, you know, SARS, H1N1, and Ebola have all occurred over, you know, the course of the last 2 decades. In your experience, as you've had to look at force majeure provisions, did you see an adequate approach to covering pandemics, or instead are you relying more heavily on government mandated closures and that like?
Vincenzo, before you answer, we have about 6 minutes, so I would say we'll close up on the recorded part, and then we have a half hour more. So we may only get to answering this question. I have a couple in the chat. Please do start putting more questions in the chat. Vincenzo, I would suggest that you turn on gallery view on your computer, because then you can look at me or others. If anyone is having trouble hearing, maybe you should turn on your camera and you could say, you know, it's good, or you're having trouble, because some of the time I was hearing you fine, and other
Yeah.
times it was cutting in and out. As Vincenzo said, you had great slides, so it was very easy to follow what you were saying, even if we didn't fully hear you. But especially in the Q&A, if you look at gallery view and you keep an eye on me, I'll sort of, let you know if you're cutting out, because I think it has to do with partly where you are in relationship. And also if you speak just louder, it helps. So.
Okay, just let me know, otherwise I will turn off the video if you don't hear me, okay? So coming back to the Andrew's question. So in my experience, I remember there was a case on 2014, an Ebola case. It was an American company. I don't remember specifically the name of the case, but it was a USA company was working in Libya or Liberia. It was in Liberia in 2014 in some iron mine, and they tried to discharge the contract because the employees came from the USA, so the company was managing the iron mine in Liberia, tried to prevent the people coming from the USA to work in Liberia. But if I remember well, the contract was not, they claimed the force majeure actually, but it was rejected because the rationale of the court decision was that they had the chance to replace the employees with no specific, specifically from the USA, but they can replace just seeking to other qualified people, or also locally people. I know that's very, very difficult to find qualified people in Liberia, but this was the rationality, and so this specific case was rejected when it was claimed the force majeure caused by the Ebola outbreak. So in my experience, I don't remember it was a decision was granted when was claimed a pandemic outbreak under common law, actually.
Right.
Thank you,
I could hear
Professor.
that.
We'll go back. Yeah.
Yeah.
Okay.
Did you have something else, Andrew?
No. Why don't we go to the Q&A? I have another question or two, but we'll do that if we have time to fill later.
Okay. So we have I think we had one question early in the Q&A that I'm going to ask, and then we'll probably then close the recording and switch. This was a question that Don Farley put in very early, and because it's about the Uniform Commercial Code, I think I'm going to start with Andrew. Although commercial transactions is often a course that our LL.M students take. So.
I remember it.
Okay, good. Okay, to test coming 10 years later. So Andrew, Don Farley's question was, and of course I know that you're a real estate guy, so this is kind of unfair to switch you over to the UCC.
Goods, you want me to talk about goods?
Yeah, right, good, sorry. So Don says, but if the contract is subject to the law of a US state where the UCC is in effect, the contract is subject to 2615, excusing performance where it is commercially impractical. How about that? And
yeah, well, absolutely. And at the beginning of my comments, I said U.S. follows common law except in Louisiana and a few rare statutory provisions. So I think that you certainly could assert impracticality there. I can't admit that I've read the comments to the UCC, Article 2 of the UCC in recent years. So I don't know if the comments to that particular section specifically call out to force majeure, but certainly you would have a statutory in a contract involving the sale of goods. You would have a contractual right to invoke a defense of impracticality.
Vincenzo, was there any comment you wanted to make on this?
Yeah, I want to add something, because when we talk about uniform commercial code, remember that the basic for the negotiation or to make impracticability a contract or wherever is the good faith of the parties, of both parties. This is essential to rise when discussing uniform commercial code. Obviously, there is a specific provision in the code. So when there's impracticability, of course, the person, the affected party, the merchant must show as soon as possible event to the other party and the good faith as to settle this case with the opposing party, and obviously rights the practicability is enforced, it's in place. Obviously.
Okay, we're now at the 2 o'clock point, so we will close down the recording and switch over to a more